I'm Mary Trosco, CLIA's Executive Director, and it's my pleasure to welcome you to our last session of our 2022 Law Conference. This afternoon we have a panel, Family Law Government Services in Manitoba. And first we'd like to acknowledge that CLIA's office is located on Treaty 1 territory, the traditional gathering place of the Anishinaabe, Cree, Oji Cree, Dakota, and Dene people, and the traditional homeland of the Métis people. Winnipeg's water is sourced from Shoal Lake First Nation. We acknowledge that much harm was done in the past and dedicate ourselves to move forward in the spirit of reconciliation. So I'd like to say a little bit about our presenters. Ingrid Pflug was called to the bar in 1990, and since then has worked for Manitoba Justice. For the first 10 years of her career, she was a Crown Attorney for Public Prosecutions. While she was with the Crown's office, she was a member of a variety of prosecution units, including domestic violence, pre-charge screening, bail court, among others. She prosecuted a range of criminal code offenses in both Winnipeg, rural areas, and in remote flying communities. For the last 20 years, she's been a member of the Family Law section of the Legal Services Branch. In that capacity, she has acted for the Director of Social Assistance, Eastman Child and Family Services, and she's also one of the Manitoba Justice Council responsible for conducting interjurisdictional support applications and support variation applications under the Interjurisdictional Support Orders Act and the Divorce Act. Ingrid also provides legal advice to the Family Resolution Service in their work for the courts and has worked on family law legislative and policy initiatives in Manitoba and sits on various federal, provincial, territorial committees that work to develop policies and practices for implementation across Canada. Outside of work, for the last 6 years, she's been a member of the Voluntary board that oversees the operation of Nova House, Women's Shelter in Selkirk. Leita Kalinowsky, as an Executive Director of the recently launched Family Resolution Service in Manitoba Justice, Leita oversees the Family Law Modernization Initiative and has led major reforms in sectors from the environment to the economy, intergovernmental affairs, and now justice in her 20-plus year career with the province of Manitoba. With a master's in public administration and honors in women's studies, her passion lies in solving complex problems and bringing diverse stakeholders together to deliver meaningful change for Manitobans. She's chair of Manitoba's Family Law Collaboration Table, serves on Manitoba's Access to Justice in Civil and Family Law Stakeholders Committee, and Manitoba's Community of Practice in Family Violence. And she was a past board member of Fort Garry Women's Resource Center. Leita leads a team committed to improving access to justice, advancing reconciliation, and undoing the harms caused by systems. She is interested to hear how we can collaborate and support one another's efforts. Michael Williams. Michael is the director of the Child Support Services Unit within the Family Resolution Service. He has an undergraduate degree in psychology and graduated with a law degree from the University of Manitoba in 1988. He's been a lawyer in the family law area since 1989 and served on the executive of the Manitoba Bar Association Family Law subsection for a decade. Michael left private practice in 2005 to join the newly created Child Support Recalculation Service as the Senior Support Determination Officer. He has remained within the service, it's now called the Child Support Service as of July 1st, 2020. So we'll start with Ingrid, and after Ingrid's presentation, since the presentations are fairly short, we'll have questions, and then we'll move on to our next presenter. So I'll let Ingrid take over. Okay, you're muted, sorry.
Okay, thank you. You would think that by March of 2022, someone would not have to tell me to unmute myself, but here we are. So thank you for having me this afternoon. I'm really pleased to discuss family law services in Manitoba Justice and what the family law section does. I'm going to try to keep my presentation to 20 minutes. I'm hoping you can actually see my slide. I'm also rather technologically not advanced. So anyway, so to discuss some of the family law services that are currently being provided through Manitoba Justice, one of the main ones that you're going to want to hear about this afternoon, and it is a relatively new service, is the Family Resolution Service. That service created some new services, some new and exciting services, and it brought some existing services under the same roof. That being maintenance enforcement was brought in. What was the Child Support Recalculation Service and became the Child Support Service was brought in. Another group that serves now serves courts that I also assist, and that is the group of family guide mediators that also do court-ordered assessments and mediations for the court. That I'm going to speak about that only briefly and just tell you that it exists, because Leita is here and she will do a fabulous presentation telling you about those services. There are other services that the family law does is we assist with the development and creation of family law legislative and policy development. We represent different government departments and agencies that have involvements in both general and specific family law matters. And we develop and assist with the revision of online forms and other resources. And we also assist with the development of family law information publications. So family law services in Manitoba are provided through two bodies. The main one is the Courts Division, and that is where the Family Resolution Service sits. And then the Family Law section, which is where I am a lawyer, and I'm with the Legal Services branch of the Crown Law Division. Now, the Crown Law Division is, you can think of it like the government's law firm. So wherever the government may have an interest in a family matter, we are the section that's involved with that. But generally speaking, the government's law firm, also you could call it the Legal Services branch, they will act for environment, they will act for education, they will act for various government departments. If you sue the government, you're going to be dealing with a lawyer from Legal Services branch, etc. So that's where I am, and that's where the family law section is. So some of the things that the family law section does is we help with the government develop family law policy programs and legislative initiatives. We work to increase awareness of family law initiatives and issues among the general public and the legal profession. And we provide legal services to government departments, programs, agencies in matters relating to family law, including the Family Resolution Service. We support the provincial government in all aspects of family law, including legislative development, providing legal advice, supporting the Minister of Justice in regarding inquiries of a family law nature. We provide advice and support to government departments and agencies and assistance to courts and police. So sometimes we are asked to participate in a committee for courts to provide advice to the courts on particular family law matters. And we do provide some assistance to the police and law enforcement agencies, but I'll talk a bit more about that later. What we don't do is represent individuals in family law proceedings or give family law advice to individuals. We can assist with providing information, but we don't act for people specifically, and we can't give someone specific family law advice to their situation. And here's just an example of some of the bodies and individuals that we do provide legal services to the Minister of Justice and the Attorney General, to the Family Resolution Service. We act for the Director of Assistance and Support Variation Matters, and that's where Director of Assistance is essentially the Director of Social Assistance. And if there if there's a court order for support that has been assigned to the director, and an individual, a payor, wants to change that support order or remit arrears that have accumulated, they have to serve the Director of Assistance, and then we will be involved in those court proceedings. We provide assistance, legal assistance to some child protection agencies, to Vital Statistics Agency, and we also act as counsel to the Director of Child and Family Services. And some of our other responsibilities that we undertake in our unit are, we are the central authority under the Hague Convention on the civil aspects of international child abduction. So that's specific to parental abduction situations. The Hague Convention is an international treaty that various countries have signed on to. And if you're a member of this, if you signed on to this treaty and you're a member of the convention, those countries agree to cooperate and help each other in cases of international child abduction. So if somebody leaves Germany with a child and they did not have a court order allowing them to do that, and they end up in Winnipeg, lawyers in our office will work towards having a hearing for a judge in Manitoba to determine whether that child can stay here or whether the child has to go back to Germany. I'm just taking Germany as an example because they are a country that has signed on. So lawyers in our office do that. And the Hague Convention also helps to facilitate access. For instance, if a child is lawfully in Manitoba, but the other parent is having difficulty having access to that child, we also work to assist with that process as well. We're also the designated authority under the Interjurisdictional Support Orders Act, and under there's certain parts of the Divorce Act that let you send documents to another province to establish a court order. And so we are the public body that administers the legal services under that. So if, for instance, somebody resides in Saskatchewan and they want to establish a child support order against somebody in Manitoba, they will complete certain forms that they will find online. That application finds its way to Manitoba, and we have that person served with a notice of hearing to attend court, and then we'll assist the court with making sure the person makes the right financial disclosure to the court, and then we assist with the hearing of that. And then when the court makes an order for support, we will draft that court order and then make sure that the completed court order goes back to Saskatchewan, and whoever needs a copy gets a copy. So that's a system whereby provinces and countries, there are certain countries who we also have agreed to do this with, where you can apply to vary and establish child support orders just interjurisdictionally through the exchange of documents. Doesn't deal with custody and access. The ISO Act is only about child support or spousal support. There's complementary sections in the Divorce Act. So recent amendments to the Divorce Act made it similar to our provincial ISO acts. And just so you know, every province has their own ISO Act. So they're all very similar, and the provinces will work together on these applications. Our office does a few other little odds and ends. For instance, provide training to service providers regarding protection orders under the Domestic Violence and Stalking Act. We participate in and contribute to various committees on family law issues, including groups within Manitoba, such as courts. For instance, we'll sit on the Child Protection Committee with courts. So we sit on the Standardized Clause Committee. That's the committee that works on and establishes standardized clauses for court orders so that all court orders use the same kind of wording. It keeps things much less confusing than when everybody can make up their own wording. And we sit on different federal, provincial, territorial committees. I sit on a couple of the committees dealing with interjurisdictional support. Other people in my office sit on committees that deal with with maintenance enforcement issues in terms of collecting support across the provinces. We also contribute to the Bar Association course. We provide the family law materials, and we update them from time to time as the law changes. And then in terms of some current legislative initiatives that we've been involved in, the big one right now is Bill 17, which is it's a proposed Bill 17, the Family Law Act, the Family Support Enforcement Act, and the Interjurisdictional Support Orders Amendment Act, or we could just call it Bill 17. So this is something that everybody in family law, policy, and law is quite excited about. Normal people may not be so excited, but we legal weirdos find this really exciting. So just to give you some background, the Family Maintenance Act, which is the provincial family support legislation, it's pretty old. It's called the Family Maintenance Act. It's like that big house that previous owners have stuck useful additions on, and over the years, each addition has now made it this kind of a bit of a mishmash. So the new act that is proposed is going to repeal the Family Maintenance Act and create the Family Law Act and vary a couple of other acts. Everything to do with enforcement of support will be in its own act. So it makes it a much clearer, better written, better organized. And I have to caution, though, that this is proposed legislation. It's before the legislature at this moment, but it still has to go through the legislative process. It's not yet law in Manitoba. It has to go through committee, and we hope that it will be passed as is, but remains to be seen. So this new provincial legislation is going to be, the big one for provincial legislation will be the Family Law Act. And the Family Law Act will have laws about parentage, parenting order, child support, spousal support. Guardianship will be in one act, and that's the Family Law Act. It used to be that if someone applied for guardianship, they had to go under the Child and Family Services Act, which probably made sense at the time, but now it makes more sense to have everything together. So it will be repealing the Family Maintenance Act, and all of those things to do with parenting will be in one act. And other things that don't really have to do with parenting will be in other acts. So provincial family law legislation. So you're probably thinking, well, there's the Divorce Act and then there's the Family Law Act. So people who were not married will not be getting a divorce, and they won't be getting relief from the court under the Divorce Act. That's just for married people. So people who had a common law relationship or who never lived together but have a child together, they would go under provincial legislation, which will be the Family Law Act, if they want to get child support, spousal support, etc. And sometimes people who are married, they're not quite ready to file the petition for divorce, but they want to get an interim order to deal with parenting issues and support. They can apply under the Family Maintenance Act and then later get a divorce. So that's who that applies for. And that's why you have federal legislation to do with family law and provincial legislation to do with family law. And the federal government changes the Divorce Act. We can't change that, but our government is now has introduced the Bill 17 to clean up our own family law in Manitoba. And as I said previously, this religious legislation related to the enforcement of child and spousal support. It's not going to be in the Family Maintenance Act anymore. It's going to be in its own act, deserves its own act, and it's going to be in the Family Support Enforcement Act. So a lot of the provisions in the Family Law Act, they're going to align now with the recently amended Divorce Act. I'm not going to get into the amendments to the Divorce Act too much because that's a whole nother speak. But the Divorce Act was substantially changed and did away with some old-fashioned terminology. Although we will continue to talk about custody and access just because it's hard to stop using those words, really it's now parenting time and decision-making responsibility. It was thought that the terms custody and access are kind of, it sounds like somebody's winning and somebody's losing, and it puts a bad taste in people's mouths, and it's just not, it's not really conducive to people working together for their children. So, which is what we all want. So, so instead of the terms custody and access, parents will have parenting time and decision-making responsibility. So that's already been changed for the Divorce Act, and now the Family Law Act will include that terminology in it now. It really focuses on the other thing the Family Law Act does, which we are very happy about, is that it sets dispute resolution, minimization of conflict, best interest of children as primary goals. That is right at the beginning of the act, and sets that as what everybody is supposed to be working towards. It's created, the Family Law Act is going to create some legal duties for everybody involved. There's now legal duties for parents, spouses, legal advisors, and the court. And those legal duties are all aimed at the minimization of conflict, at dispute resolution, because really court is frankly the last place where things relating to children should be decided. It's a fallback, but it's not ideal. Best interest of the child or children is the prime consideration of the court in making a parenting order, a contact order, or a guardianship order, and that's under the Family Law Act. The old act said that too, but this now really sets out the lengthy list of factors that are to be considered in determining the best interests of the child. In my PowerPoint, you'll see I refer to contact orders. So that would be, contact is defined as access by somebody who's not a parent, and that would be something that a grandparent would apply for, a step parent, an aunt, an uncle, something like that. And that also used to be under the Child and Family Services Act, but now it's going to be in the Family Law Act, again, where it makes sense. So the family violence is very first and foremost in the best interest considerations in the Family Law Act. So in addition to that lengthy list of best interest considerations, the court has really, or the legislation really highlights that the court is obliged to consider the impact of family violence in determining the best interest of the child. And so in addition to all those best interest factors, they've added factors that are specific to family violence. So if there's family violence, the court has to consider some other things. And for instance, the court is to consider the emotional and psychological harm or risk of harm, not just physical, but emotional, psychological harm or risk of harm. So that's something new. That's a departure, and that's something we're quite happy to see. Relocation. Now that is when basically one parent wants to move. So the Divorce Act has now specific rules around relocation. The Family Law Act is now aligning with those, and essentially it establishes a regime where a parent who has parenting time with their child wants to move. So if that parent wants to move and they have parenting time, whether or not that's the majority of the parenting time or less of the parenting time, they have to give notice to the other parent. And if the person has substantially equal parenting time, the other person that's not going to move, not planning to move, the onus is on the one that wants to move to demonstrate that the move is in the best interest of the child. So it's going to be really interesting to see how these relocation provisions shake out. And when we start seeing some written decisions about it. Lawyers advising clients on relocation in the past it's been really difficult because the law has been sort of a patchwork of decisions, and you can see facts in two cases that seem really similar, and one went one way and the other went the other way, and it's really difficult to reconcile those decisions when lawyers are trying to advise clients. So we're hopeful that these provisions in the Divorce Act and the Family Law Act about relocation will provide some certainty about this. So I'm not sure I'm doing for time, but I don't want to, I want to hit the highlights, so to speak. So family law inquiries, family law section provides family law information in response to inquiries from the public, service providers, other government agencies and lawyers. Our contact information is on the screen. And this would be more, these numbers would be more for the service providers or people who want general information. People who want help with their family matters, Leita will focus on that, but I will give you that contact information. That's through Get Guidance. So these ones are specifically, for instance, ISO questions. That is if you have a question about interjurisdictional matters, flb@gov.mb.ca. That's if you have general questions. And there, if you're a member of the public seeking information about your own family law matter, you want information, guidance, or support, you're encouraged to contact Get Guidance during regular business hours. And there are the numbers for Get Guidance and the email address. There's also, and I'll just provide you some information about some other family law resources. Manitoba Justice Online, if you go to www.gov.mb.ca/family law, there's a ton of useful information there. It's really kind of a one-stop information about court-mandated parent education. That's something that parties have to do before they can progress through the court system. Issues about child and spousal support, information about common law partners, information about early resolution, information about enforcing child or spousal support orders, how to apply for or vary child or spousal support when the other person lives outside Manitoba. That's the ISO Act that I told you about. Adoption issues, parenting plans, dividing property. I'm just giving you a flavor of some of the things that are there. And so I encourage you to look at that website for information. There are other resources for accessing information about family law. So Manitoba Courts and www.manitobacourts.mb.ca also provides lots of legal resources. For instance, they have links to CLIA, this fabulous organization, to Legal Aid Manitoba and the Legal Help Center. If people are looking to actually access the rules of court forms, everything has to be on a particular form, and practice directions, that's where you also can locate that on the Manitoba Courts website. So just give you a real quick summary of what we do. Family law section, we assist the government where they become involved in a family law matter, provide services. We're the central authority under the Hague Abduction Convention. We're the designated authority under ISO. We assist the Family Law Resolution Service. Just a little summary. We assist law enforcement with interpreting custody orders, For instance, we will sometimes be contacted by law enforcement when they have somebody's calling the police about custody orders, and they'll turn to us for some assistance with interpreting that order. Parental child abduction within Canada, not internationally, so it's not the Hague Convention. We are involved with those as well. We will advise law enforcement on what to do, and ultimately the goal is always to just get the kid back. Charges is kind of the last resort. We just want the kids back, but if charges have to happen, then it's the Attorney General authorizes those charges, and we advise on whether or not to charge under the specific sections of the criminal code that deal with parental child abduction. So sometimes people don't realize that what they're doing is an abduction, and oftentimes if people are spoken to and they're advised of what the situation with the law is, a lot of things can be resolved in that way. But if it comes to it, then there is the charges under the criminal code. If you have any questions of me that you think of after this is all over, here is the contact information again for the Family Law Branch. Here is our phone number. And that is it. So if you have any questions, I will definitely try to answer them.
Okay, there are a couple of questions. First of all, does Manitoba have Crown Counsel specifically trained or dedicated to domestic abuse?
Yes, there is a, so when it comes to, so for by Crown Counsel, do you mean Crown prosecutors, or do you mean lawyers within the family law section? Because there is a specific unit in prosecutions called the domestic violence or family violence. The name changes from time to time, and I used to be in that. And yes, those lawyers that deal with those Crown prosecutors do have training, and they have experience in those matters. So I presume you're talking about criminal charges.
Okay, if not, then maybe the person can send us an additional question.
Yes.
And the only other question so far has been about the slides being shared, and that's already been answered by Leita, that you will be sharing your slide decks. So that also answers the question about information, contact information. So you'll get those. Does anybody have any other questions? Okay. We'll give it a minute or so. And
okay.
In the meantime, I guess Leita can set up her, oh, here we go.
If they come up later, then we can always answer later.
Okay. If you have been charged in a domestic violence incident, your file is forwarded to who?
So if you've been charged, as in the police have laid a charge of assault or one of the assault charges, then if the police have been laid a charge, then the file and that information goes to the Crown prosecution services, and they're the ones that are charged with the responsibility of conducting that prosecution. So that's not our group. I'm in the Crown law. The prosecution services deals with the prosecution of domestic violence matters.
Okay. Yes, they at the scene, so that answers that question. Okay, so far we're on top of the questions.
Okay, great.
Okay, so I guess we'll wait another minute, and if there's nothing else, because we're right on time, then I can let Leita share her slide presentation. And of course, as soon as I say there's no more questions, that's when they pop up. But we'll assume there aren't any for now.
Oh, I see Ron Busky there. Hi, Ron.
Oh, and here we have okay. All right. Okay, then perhaps we can start with Leita's presentation. And again, there will be time for more questions at the end, hopefully as well. Okay. Okay, I think we're having a bit of a technical glitch.
Is Mary frozen? Or sorry, is Leita frozen?
I think she's going to be, Leita will be rejoining us. So sorry, bear with us. We don't usually do, oh, there we go. There's Leita again. Okay. Yeah, we can't control the technology.
Michael, I don't see this screen, the PowerPoint presentation. Are you just loading it up?
I will get it up as best I can. I use a toggling two screens. Let's see if this works.
Okay. I've dropped a couple times. The connections dropped, and so hopefully I can get through my presentation without that happening again. But in the event that it does, it sometimes just flutters and takes a minute for me to come back.
We can't control the internet.
Yeah. Yeah.
So in the meantime, people can think of questions while we're setting up.
Yeah.
Oh, there we go. Screen share.
Did that work?
Yes,
it does.
Yeah. Now if you start
to have it up.
Perfect. Yeah, if you can start it from the beginning slide, I guess. There we go. There, perfect.
Sec. All right.
Excellent.
So I will advance Leita to assist you, if or can you control it? Are you able to control it yourself, or do you want me to just run through?
I'd appreciate if you could do that, Michael.
I can do that.
Okay. Sorry, I'm just. Okay, so my name is Leita Kalinowsky, and unlike Michael and Ingrid, I'm not a lawyer by background, and I understand we have lots of service providers in the audience. So I am the executive director of a newly created family resolution service. I'm just getting Michael to move to our first slide. For about the last 24 months, we've been engaging Manitobans about family law issues. And I think everybody in the audience will certainly be aware that there's an impact to folks involved in separation and divorce, especially children, including risk to physical and mental health. There are intergenerational impacts, as well as social development seen by interpersonal relationships. And in our journey talking to Manitoba families, we heard a real strong desire for greater empowerment and independence. Over and over again, we had families tell us that they were the best person to make decisions for their family, and they wanted to be able to resolve things in a positive way. Next slide. And so research was also telling us that divorce is considered an adverse childhood experience that is harmful to children's brains. We knew that emerging Canadian research is showing that up to 80% of families going through separation and divorce are experiencing some level of intimate partner or family violence, whether it's situational or all the way up to and including coercive control. Manitoba Justice, including Ingrid and myself and some of our other colleagues, we participate in a Winnipeg and area community of practice on family violence, and we also belong to a national table. And the overarching goal of this project is to enhance support to survivors of violence through the family law system by increasing opportunities for family law practitioners and other generalists that provide services to families, to have training, guidance, and resources to support trauma-informed practice, and to improve the coordination of services that will enhance the safety and well-being of all parties, whether it's the user of violence, the survivor, or children. There's some really wonderful resources that are available online, and we'll be sure to share that link with you guys. Next slide. So I think it's long been recognized that court is not the best place for families, that couples and families who want to separate or get a divorce, settle their child custody, spousal, or child support and property matters were heavily dependent on the courts until a couple of years ago. And courts are are expensive. They're inaccessible. Ingrid talked about winners and losers. The whole court process can really fuel acrimony and impact the emotional and physical well-being of the participants and children. And even though our Chief Justice of the Court of Queen's Bench has made some significant reforms that I'll touch on in a second, it can still take families up to 15 months to get a court date. And self-represented litigants, and they're growing across Canada, struggle to path their way to court. And even medium income families and survivors can't afford the legal advice needed to ensure that their rights are protected. And that's when former Minister Stephenson, now our Premier, presented Justice with a challenge. She believed that there was a better way, and she challenged us to think about an out-of-court model. And so over the course of a couple of years, we engaged with Manitoba families, with service providers in all three sectors, and we worked to gain a deeper understanding of what this means to families and service providers, and what were the gaps and pain points, and how could we better support them. Next slide. So around the same time, as I mentioned, Chief Justice Glenn Joyal was recognizing his influence over this broader problem, this broader social problem. And he launched something called the Court of Queen's Bench Scheduling and Case Flow Model. And really what he was trying to do, continues to strive to do, is to commit to minimizing delays, complexity, and cost for families who are dealing with family law matters. And so this new scheduling model established reasonable, predictable, and finite timeframes. So now families are guaranteed a case conference within 30 days of triage and a trial within 12 to 15 months of the first case conference. And there's certainly provisions for emergent situations where those are listed there at the bottom, where those cases can move more quickly. But for anyone in a regular family law matter, they have to meet certain prerequisites to get before to get to triage. And those are, they have to attempt resolution, and that can be through any means. They have to complete the mandatory for the sake of the parenting course, which is online. They have to draft a parenting plan, and they have to do their financial disclosure. And so this is where the changes that the provincial government have made are really quite complementary and symbiotic with the court changes. So the Manitoba government committed under the banner of family law modernization to putting families first and making family law more accessible, affordable, and collaborative. And through our engagement over the past couple of years, we've moved some legislative changes and some service innovations. And there's a list of those on the right-hand side, and I'll get into each of those in a little bit more detail. So prior to the piece of legislation that Ingrid just discussed, next slide, the government introduced a large piece of legislation called the Family Law Modernization Bill. It's now many of the areas of this multi-piece of legislation have now been enacted. It contemplated establishing a first in Canada family resolution service. It clarified court or appointed family assessor guidelines and the options for judges to order costs. It enhanced the authority of our maintenance enforcement program. It established a new child support service program that Michael's going to talk to you more about today, and enhanced Michael's old program's ability to recalculate child support in a broader range of areas. And it facilitated private arbitration for family law matters. So this was a significant change in family law in Manitoba. And I think one of the big things people think about when they think about that bill and now act is the out of court model. And people really, I think there was some confusion in the beginning about thinking we were shifting things from court to, a more friendly out of court model. And what I really, really want to underscore in our approach is that through engagement with families, we recognize that modernizing family law is recognizing that court's damaging for families and matters should be resolved outside of court as much as possible, but that systems overall are damaging to families. We heard a lot from Indigenous community, from immigrant refugee families, many, many families about the damage that traditional bureaucracy can also cause to families. The good thing is that when we commit to such a shock, it allows us the potential for massive system-wide change. So our commitment is to move beyond simply shifting. It's not about place, It's not just about moving from court to out of court, but it is about really challenging the culture, the qualities, and the characteristics that underpin how traditional public services have been delivered, and to try and move to more of a transformational approach, an approach that demands that we listen to what families ask for, that the services be empowerment and strength-based, gender equitable, multicultural, that they recognize class, that they're self-determining, trauma-informed, family and child-centric, and inclusive of all the different families that we serve. And so I could go a little public admin nerdy on the audience here, and I'm not going to spend a ton of time on this, but this is a little bit about what we're talking about when we say challenging systems. So we really are trying to do things in a different way. We undertook a co-design approach, so we designed the new service with families, involved them right at the front of things, defined the problem with the people impacted by it. We work as a single cross-functional team. We're continuously challenging and learning and trying to take an innovative approach. Next slide. So when we engaged families and service providers from all three sectors, we asked them, what would it look like when we got this right? Tell us what it would look like. And this is what we heard from people. And so these principles have really guided our reforms, our service innovation, and how we deliver our services to families. They're the test, they're our North Star, and they're how we know if we're on the right track. And so then we went a little further because we were bringing together services that had existed in the Department of Families, Department of Justice, a whole bunch of existing services. We were enhancing those services. We were adding new ones. And so we really wanted to make sure we were all operating from a consistent set of values. We also work very closely with over 20 service providers from the not-for-profit and private sector. And so we work together with the input from families and those service providers, and we designed a set of values. And these are here for you to read, but they obviously really connect to some of the legislative changes that Ingrid talked about. So next slide. So we launched a voluntary out-of-court resolution model, and this is really launched in June of 20 during the pandemic, which was a big challenge. And it was really to test that out-of-court model that's referenced in the FLM Act. The Act contemplates a mandatory model, and what we wanted to do is test a voluntary approach to see what worked, to make improvements, to hear from families, and to learn. And so this out-of-court resolution service seeks to support family well-being and healthy relationships by delivering client-centered services to Manitoba families that help them resolve their disputes in a collaborative, fair, affordable, and timely manner. It's a seamless continuum of wraparound and affordable services. We enhanced front-end support. We really try to help people resolve out of court totally where possible, to narrow issues in dispute. And if we're not able to do that, to help prepare families for court. We support families in navigating that QB scheduling model and meeting those prerequisites for court. And it's part of a broader paradigm shift that's happening across the country, really, in how family law services are delivered, really trying to focus on more restorative approaches and trauma-informed approaches. And we work as a multidisciplinary team, as I mentioned, with other service providers, trying to path our families amongst folks so that families don't have to learn the system to navigate it. Next slide. So what do we offer? There's a little overview here of our services, and I'm going to go into each of these in a bit of detail. This is the website that Ingrid mentioned. So one of the things we heard is that families couldn't find information, and there was lots of incorrect information online. And so with input from those that we engaged, we designed a one-stop online hub for information, for family law information, self-serve resources. This contains lots of resources, a searchable database by region and by topic, and we're continuously working to improve this website. In the next year, we're hoping it's going to have an online portal where families will be able to apply online and work through their issues on their own, or to connect to us for service assistance. Next slide. So we have a team of family guides. We heard from families that they wanted family guides. Those family guides are a multidisciplinary team of specialists. We have domestic violence specialists or IPV family violence specialists. We screen for intimate partner and family violence and children at risk throughout. We've partnered with Winnipeg Police Services, and we have staff at the 911 call center so that we can connect people to social supports early. That team supports people with risk assessment, safety planning, protection order applications, and information. And that's delivered in partnership with Victim Services and Justice and with Winnipeg Police. We have mediation and comprehensive co-mediation. We help families mediate parenting arrangements or separation agreements. And we have family guide experts in court process and procedure that can help people navigate to court. They can help point them to the right forms. Ingrid touched on that. And we even do some court order drafting in certain situations. We do not provide independent legal advice, but we do make referrals to legal advice, to social and financial supports. And we also have the child support service and maintenance enforcement. So next slide. Some of our team also does assessments. So designated family evaluators often complete court-ordered assessment reports at the request of a master or a judge when the court is considering how the needs of the children might be best met with respect to access. And in certain circumstances, we also do voice of the child reports to help bring children's preferences to court without them having to participate in the harmful process of testifying. Next slide. So I'm not going to spend a lot of time on child support because Michael's going to talk about that in more detail. Our maintenance enforcement program helps collect family support to set out in court orders and agreements. The majority of the support orders that they work on are for child support and Section 7 or special expenses. They have the authority for a number of out-of-court options, which were expanded in that act that I talked about earlier. And between our expanded powers for MEP and Michael's Child Support Service, we're able to move thousands of matters out of court that people would have formerly needed to go before a judge for, and to save families up to $41 million a year in court and legal fees. Just over the last year, next slide, 2 children's access agencies joined our team. So in Manitoba, judges and masters can order supervised parenting time and exchanges for families experiencing intimate partner or family violence. The Winnipeg Children's Access Agency and Brandon Friendship Center joined our team in the last year, and we're working really closely with them to expand their services over the upcoming years. So stay tuned for more information on that. Next slide. So this just gives you a bit of a snapshot of what things were like before and some of the pain points that we heard when we consulted with families in Manitoba and how we've changed. We've got self-service options, early support and assistance for those who need it, ability to save $41 million in court and legal fees every year with our legislative changes. We've got a one-stop shop where people can come, an online hub where all the information's in one place. We have a central intake team called Get Guidance. Ingrid talked about that triages and refers families to all the services that we deliver or other ones in the province. We work as an ecosystem. In the last couple of years since we've launched, we've served 60 times the families that were previously being served, and we've leveraged 5 times the in-kind and financial support to continue expanding our family law services in Manitoba. We deliver our services by 3 channels. They've been digital for most of the pandemic, but we do offer phone and in-person service, and we're going to be getting back to more in-person service in the coming months. And we're trying to take a culturally informed trauma approach and tailor our services to the unique social, financial, and legal needs of each individual family. So next slide, we think that modernization is working. Thousands of families are benefiting. As I mentioned, we've seen 60 times the number of individuals previously served. We're working in collaboration with others. Victims of violence are supported earlier and throughout. Previously, we only supported victims of violence when there were criminal charges, so much later in the process. We're trying to focus more on prevention and intervention. Next slide. Some feedback from the families that we've served there. And with that, I think I'm going to end things. I'm just going to note that my contact information is here as well, and a link to the website. And if you want to check out some of the things that we heard from people and the actions that we're committed to, there's some hyperlinks here. So with that, I'm just going to end things and give an opportunity for questions. Thank you.
Thank you, Leita. I don't have any questions yet. We'll wait a couple of minutes and let people have time to submit some. Okay, I know there were some questions about sharing the slide decks and sharing different website addresses, things like that. So I'll make sure that I send that out to you all, hopefully next week. To all of the people that registered for the presentation, I will do that. I promise.
Maybe while people are thinking of questions, I could also just note that we often go out to agencies and we do them virtually. We've been doing them virtually during COVID. But if you have interest in having presentations given to your staff, if you think there's opportunities to collaborate or partner on things, please reach out. We're always interested in supporting those kinds of requests as well.
Okay, there's a comment. So happy to hear about these changes, particularly the added IPV service and consideration of emotional and psychological harm. Okay. And okay, we'll wait a minute or two for some more questions. There's a lot of information to absorb. I think that's.
Also, another pitch, we're hiring right now. So we have positions being advertised. I'll share those with Mary. I think the closing date is this upcoming Friday. So there are positions in victim services and positions in our family resolution service branch. We're looking for people, Indigenous folks, BIPOC, people from different backgrounds with conflict resolution or social work backgrounds. So please get that word out and check out the Government of Manitoba website for those positions. We're always interested in attracting new folks to the Manitoba government.
Okay, one of the comments was, can you please provide contact information for the workshop requests?
So we tend to do a version of this depending on the organization. So if it was a shelter community, a domestic violence service provider, we might tailor a little bit more to that. So I think we've done a lot of academic institutions, so presenting to students about what we're doing and where we see the future job opportunities. We have the ability to deliver the presentation in English and French. If we have lots of Francophone partners in the community, I know that's often a consideration. So I would just say reach out and tell us what your needs are, and we can tailor.
Okay, who would they contact? Would they contact yourself, or who would they contact?
Yep, me.
Okay. So
and then I'll find the right people in our organization. Yeah.
And we do have a question, another question. Has there been a reduction in the number of trials given the new interventions in court diversion?
Yes, I don't have the stats. I know the Chief Justice is keeping track of that. I know our stats, we've resolved 5,000 matters since we launched outside of court. I think what they're finding is there's certainly a place for court. We have a certain ability to resolve some aspects of a case outside of court, but even if a family consents, they still may make a consent application to court. What they're finding is they're resolving a greater number of cases pre-trial. And so judges are really focusing on mediation and working with the parties at the triage. And so I think that's a real positive change. The prerequisites, they're resolving a greater number of cases pre-trial.
Okay,
I do know that when we get involved in assessments, for example, when court-ordered assessments are made, they're resolving up to 90% of those cases pre-trial. So I'm not saying that's totally us. That's one factor. I think the work that we do together with the courts really helps resolve pre-trial and reduce that conflict, that really adversarial aspect of things for families. So yeah, we're starting to see a difference. More work to do though.
Okay, any other questions or comments? You can put them in chat or the Q&As as you likely know. Okay, well, you'll have a chance to ask some more questions. I'll let Michael take over now. Mute myself.
All right, I think we should have my presentation up.
Yes, it is up.
So the Child Support Service is actually a unit of the Greater Family Resolution Service, and we have been, a second, I seem to be temporarily stuck. Let me see if I can figure this out. Doesn't seem to want to launch for me. Just 2 seconds here. Can't seem to be able to launch my presentation. Let me just see if I can. There we go. All right, so Child Support Service is a unit of the Family Resolution Service. I think back until July 1st of 2020, we were known as, I think the term is one-trick pony, which, as I looked it up today in Webster's dictionary, was a bit of an insult. You could only do one thing. You may do it well, but you're restricted to doing one thing only. And we actually, for many years, wanted to do more. And so as of July 1st of 2020, with our new legislation, we were able to do a lot more for people. Up until 2020, we've been doing recalculations, and we still do. Recalculations are pretty simple. There is a child support order or an agreement or a family arbitration award, and that arbitration award or agreement or order specifies that one parent pay the other parent a table amount of child support. And we would get fresh income, and we would then determine what's the applicable amount under the tables that a parent should pay to the other parent. Fairly narrow in terms initially, because we were only able to do orders. Now we can do not only the orders, but the agreements and the family arbitration awards. So we can recalculate, but that's not really the exciting thing. The really exciting thing in our new world is the fact that we're able to make an administrative child support decision. It's called a calculation. This is where there's no prior existing child support order, agreement, or family arbitration award. So rather than a parent really only having one really big option, which is to go to court, which these days no one wants to do, we were able to now actually assist a parent. They can make an application through the website, and Leita's provided the website for the Family Resolution Service. When you click on child support, it's actually called Money. The tab is actually called Money. And the child support section pops up and the application forms are there. So a parent can make an application to our service without a fee and ask for both the table amount of child support and potentially Section 7 expenses. So this is all new. We're not the first province to do this. Ontario sort of started this, but in Ontario, it required both parents to agree. In Manitoba, both parents don't have to agree to our service getting involved in making the initial child support calculation decision. We certainly welcome both parents to come forward. They can make a joint application, but primarily this is a situation where one parent has probably tried over a period of time to engage the other parent to actually voluntarily pay child support, Having failed to do that or entice them to enter into mediation or some other alternate dispute resolution, the parents are left with really only two choices: go to court or use our service. And since July 1st of 2020, we've been receiving about 150 applications a year, and that number is steadily growing for people seeking our assistance. So there's certain legislation that we operate under. It's the Child Support Service Act, and we have our own standalone regulation as well. That gives us the legislative authority to do what we need to do. And we deal with parents, whether they're married, whether they were cohabitating, or just had a child together. So in fact, there was no cohabitation. So these are the sort of categories of people that we can assist. It's a very broad group of individuals that would qualify for the service. I just wanted to touch very briefly on the child support tables. Often people don't really understand what they are. Each province and territory has its own child support tables. They're based on statistical analysis done of the average expenses and costs of individuals in each of the provinces or territories. There's complex calculations done as to what the needs of children are, but what they are is a one-size-fits-all table based on the income of the payor. There's a number of adjustments to get to that point as to what the income is, but basically one parent's income is considered and applied across the tables. The tables are not consistent. They don't remain immutable over time. They actually change from time to time. The tables were last changed in 2017. The information I have is they're likely not going to change any time soon, but that's the starting point, the tables. So the tables are the base, and they basically were designed to cover the typical expenses that people would have: accommodations, food, and the clothing and other sort of basic expenses of a child. Do they actually cover all the costs of a child in a particular situation? No, they really weren't designed to cover all the expenses, but they're sort of an attempt to do the base amount for children. Over and above the base table amount, there's the special or extraordinary expenses that people talk about. And this little chart just sort of shows you the 6 categories of these expenses: the childcare, health insurance premiums, health expenses like orthodontia, prescription eyeglasses. There can be education, primary and secondary expenses, post-secondary expenses, that's university, college, vocational training, and the good old extracurricular activities, which generates most of the disputes. Is little Johnny or little Susie's hockey expenses reasonable? Are all the other extracurricular expenses that a child may have reasonable in all the circumstances? These expenses are proportionally shared by the parents. So actually you look at the incomes of both parents, and they proportionally share the net amount of these expenses between themselves. So we will do these expenses as well. When we're doing a calculation, we can make an order under the categories of childcare, health insurance premiums, and health expenses, even if one of the parents doesn't agree. Usually that's the payor. For education costs, both the primary and secondary, post-secondary, and the extracurricular expenses, that actually requires the agreement of both parents. So there's a little wrinkle there in terms of what we can do on those types of expenses. Most of the orders we see, about 60% are just for the table amount. And so we only really do the Section 7 expenses about 40% of the time. I've set out in my next slide the administrative calculation process. Someone makes an application. Again, it comes directly to the child support service after the parties complete an intake form. There's no fee to apply. If you meet the eligibility criteria, the service issues a notice. It's personally served on the other parent. Often the service will be able to arrange for the service to be done. Usually we have access to sheriff's officers and other individuals who do the service. And once the parent is served, they have 21 days to provide their financial information. Now, I don't think it's any secret when I tell you that not everyone cooperates. About 40% of the time, a parent will not cooperate. What do we do to find out what their information is in terms of what they earn? Well, we have certain tools. Our number one tool is we serve a request for information on an employer, and the employer will provide us with the payroll information for that parent. If all else fails and we have no information at all about what the parent actually earns, we can deem them to be earning the annual income in Manitoba under our legislation. So they can be deemed to about $24,752. And so they will pay child support on that amount of income. I've just set out here the process and how we arrive at the decision. So we determine whether based on actual or deemed income, they apply the child support tables and the Section 7 expenses. We make a written decision, gets registered with the court, copy goes to the maintenance enforcement program. Each parent gets a copy, and either parent is free to oppose it by going to court. Do a lot of our orders get opposed or appealed? The answer is no. We estimate that maybe 2 to 3% of them are subject to some sort of an appeal or an opposition. Usually it's about issues that actually aren't related to the determination of income. The parties have an issue with respect to parenting arrangements or some other issue that they want to resolve. I've got the slide up for administrative recalculation. So again, we've always done that since we started in 2005. It's really easy if someone has an order, an agreement, or an arbitration decision. Really easy if it's an order. All they have to do is attach Queen's Bench Form 70W, check off the box, literally check off the box, and they're in the program. If they decide not to join our program, right after the court order or agreement is made, then they can actually make an application at a later date. There's no fee for that application. And so we get basically some people deciding to opt into our service as soon as possible, right after an order or an agreement is made. And some people decide to defer the issue. Maybe they attempt to work it out between themselves, that fails. And then at a later date, they apply to the service. Our services are not infinite in terms of their capacity. So we have generally a rule under Section 21 of our regulation. The first recalculation occurs 1 year after the court having made an order, or we make a decision for a calculation. And then we move to a 2-year cycle. One thing that we did do and brought in for the first time in our new program is that a parent can apply for early recalculation. So if something's come up, there's a change in circumstance, loss of employment, or a child perhaps is now an adult, is no longer in need of child support, they can apply early. There's a separate application to apply for early recalculation as well. So we've tried to beef up and try to make the service more accessible. There are some restrictions, and most of them have to do with the fact that we're much more open in terms of what we can do under our Family Maintenance Act. That act, of course, has been discussed by Ingrid, will be eventually changed to our new Family Law Act. Under federal legislation, though, we have a lot of restrictions. I've just thrown a few of them up in terms of restrictions. So we're a little more restricted in terms of what we can do if it's a matter that was a subject of a Divorce Act order for child support. But we can still do many of the orders done by the court under the Divorce Act. I've just talked briefly about some of the restrictions. I've just set up on my most recent slide that I've got up. Some of the process for the calculation decision, very similar for calculation. The bottom line is we make a decision, it's enforceable, it's registered with the court, maintenance enforcement can oppose it. Can enforce it, and a parent can oppose it if they wish by making an application to court. That in a nutshell is the service. We've really tried to make it as simple as possible. There's no real expense involved to a parent, whether it's calculation or recalculation. For most of the people we deal with, they seem to be satisfied in terms of the services that we're able to offer. If it's a very technical issue or an issue that we can't deal with, there's other options. Obviously, court remains one option, but there's always going to be mediation is certainly an option. Parties can do a number of different alternate dispute resolutions. There's collaborative law. There's various other ways that you can resolve a support issue without having to go to court. So we're one option, a popular option, but not the only option that's available to parents. And with that, I'll take any questions.
Okay, we do have a few questions. First, in relation to child support, if you are in a relationship, married or common law with someone, is their income counted as part of your income when considering child support amounts?
Always a good question, one that we've got probably 10,000 times. And the answer is, for the most part, if it's the table amount of child support, the income of the current new partner, not relevant whatsoever. It is technically relevant if you're doing a Section 7 special or extraordinary expense or certain circumstances where the new partner's income could be relevant. And sometimes if someone says, I don't want to pay the table amount of child support, and I want to trigger a claim for undue hardship, well, that's a special case where potentially the income of both of the parents' new partners or spouses could be relevant as well, but that's relatively rare. So the general rule is table amount of child support, it's just the income of the person who's going to be paying child support. But there are a few exceptions.
Next question. If it is suspected that the income tax calculations of one of the parties is false, who is required to provide all the documents that prove the calculation? The party suspecting the problem or the one who may have falsified the documents?
Well, that's a good question. Fraud is rare. The biggest problem we have is just getting the basic information. Have I ever seen someone submit false information? Yes, absolutely. Often, it's difficult to tell if someone is not providing the appropriate form as doctored a document. I would say 95% of the time, the information that we eventually get is accurate. It's not been fraudulently obtained or a document changed. Certainly, we're open to the other parent providing any information they may know, or anyone that could lead us to someone who may have more accurate information. So generally speaking, our biggest problem is just getting the basic information, not actually getting false information. So that really is the big problem, what we have, getting the basic information, the tax return, the payroll information. That's really what takes up most of our time, is trying to get the very basic information that a parent is really under a legal obligation to provide at all times. It's just, unfortunately, that around 30 to 40% of people won't provide their information, and we have to try to chase it.
Okay.
Michael, can you say a little bit? I know I want to put you on the spot, but we get this question a lot from the maintenance enforcement side, and from an enforcement perspective, there's certainly investigative powers. Do you want to talk a little bit about that in that context, just to give the bigger picture?
In terms of investigative powers, I mean, we certainly have in the past been able to get information. We have the power to serve a request for information on any third party under our legislation, in Manitoba at least, and get quite a bit of information. What we're hopefully going to be getting very shortly, though, is the gold mine of information, which is some federal information. So we're working certainly with our partners in the federal government and other provinces and territories to actually get, hopefully in the near future, for the very first time, easy and relatively simple access to basic income tax information. The income tax information is really what drives child support determination, and that's the one thing that's been off limits to us since our service started in 2005, and has been a problem going back decades. That's been actively worked on now, and hopefully in the very near future, we can access that federal information. For the most part, we deal with provincial information, and we use every available provincial database that we can get access to, whether it's motor vehicles, whether it's employment income assistance, very limited information there, information from maintenance enforcement, one of our units of the Family Resolution Service. we'll cast a wide net out to try to get the right information. But the number one best source of information, generally speaking, is an employer. If someone's not cooperating, they will provide the T4s, the pay statements. They'll give us a lot of information that assists us in determining someone's income. So it can be a little detective story, and my staff like the challenge of trying to track someone down. You have to first find the individual, which is often difficult. And secondly, you have to get information about what they're actually earning. So that challenge requires our partners to assist us, and is something that my staff, quite frankly, view as a challenge to try to be able to get the right information to determine someone's actual income. Again, we'll deem income to someone, but we don't like to have to do that. We want their actual income for our purposes. So we rely on information from all our partners to try to put together a financial portrait of what someone's actually earning.
Okay, a couple more questions. Where would I apply for child support? This person's asking.
Well, the easiest place to get it is the Family Law Hub that Leita posted. That website for the Family Resolution Service is the best source of information. A lot of work went into it. There's a lot of information about child support. There's a piece on the Maintenance Enforcement Program as well in terms of what their role is. So the FLMB's hub, as we call it, the acronym, is really the primary source, and all the documents are there, the forms that we use an intake form, we have application forms, they're all there, and that is the primary source that is people use to access the service. They can always call us, but the hub is really designed to allow people to get some education piece in terms of child support, and all the forms are certainly there. We try to make them user-friendly, simple to fill out, and again, there's no fee.
Okay.
Just gonna add, I'm gonna make it clear the link to the application form in the presentation. I'm just gonna confess to you guys, we launched during the pandemic, we weren't fully staffed. And so finding the link to apply in the intake form is a little buried on the website. And we did that intentionally because we didn't want to overwhelm the service before we sort of tested things out and knew that we had the capacity to meet demand. So I will make sure it's really clear in the deck that I send to Mary. I just want to add to what Michael's saying, that it's really important because lots of times families don't know, or individuals coming to us, they don't know what all of their issues are. So we have this intake form that we ask everybody to complete, and that allows us to screen and triage people for all the services that might be applicable to their specific situation. So families or applicants don't need to know what they need. So we do that assessment on every client that comes to our front door.
Okay, there's a couple more questions. Why are the table guidelines not changing even though inflation is high?
They're actually based on taxation rates, and they also rely on data that takes a long time for the federal government to put together about the extra costs. The tables are not tied to inflation. They're actually tied to income tax rates. And they're only done every few years because it is a fairly mammoth task for the federal government to put together the numbers. So it would be, in a perfect world, they would be done every year. But since they rolled out in 1997, they've only been changed 4 times. And that's something that Manitoba doesn't control. These are federal guidelines, but hopefully within the next year or so, I'm aware that the pandemic is sort of impacted in terms of getting the new numbers together. So you're probably a couple of years away before the more recent tables are out. So you're probably going to be dealing with these tables for another 2 to 3 years.
For the recalculation service, can a payor make a request to review their payments through your service, wondering if there is leeway if their income is greatly reduced?
Well, the key is we use current income where possible. Current income is what your situation is right now, not what was on last year's income tax return. And that's the one thing that sort of differentiates our service from other services. We will look at what you're doing now. Other services across the country, because of various reasons, tend to look at the income tax return, but income tax returns really tell you what someone earned last year. If we're talking about what someone's doing in August or October of 2022, you'd want to know what they're doing in 2022. So we use current income where possible. So we would use it in pay statements, EIA, EIA situation, the monthly statements, employment insurance benefits. We'll base it on the current, as long as we're satisfied that we've got the true financial picture of someone. Now, there's some types of income we can't adjust. If someone's a farmer or a seasonal employment, very difficult to use the current approach, but we will use what they're currently earning as opposed to what they earned last year, provided the income was clear.
Okay, and now a question about, can you provide the form they give individuals to fill out to consider the relevant issues? I think that's the form you were talking about, Leita. Oh, you're typing in an answer. Never mind.
Yeah, that would later be talking about the family
Yeah.
resolution has a wonderful little triage form that really kind of tells every service provider that we have in our unit, and there's many different units, exactly what someone's circumstances are, so we can all get a sense as to what their needs and issues are. And often the child support service is nearly one of 4 or 5 potential service providers.
Okay, then and this question, if the father doesn't pay on time, is it possible to self-refer to the maintenance enforcement program?
Well, the golden rule has always been, whether I was in private practice or with a service, we will always direct people, if they have an order or an agreement that's registered with the maintenance enforcement program, to be proactive. You're proactive with maintenance enforcement. If you have an issue, you can apply to them for an administrative suspension if you have a good reason for not being able to pay. And then that gives you the time and the opportunity to make an application to court or to come back to the child support service to get a recalculation done. So there's many things that someone can do if they're falling behind in their support obligation or their circumstances have changed. We're part of the answer, the solution. The other part is to go directly to the maintenance enforcement program. They have a whole bunch of new things that they can do since 2019 to assist the payors, and in allowing them the time. They can enter into agreements in terms of payments. They can apply for these suspensions of enforcement. So there's a number of things that can be done. And that information, by the way, is on the website as well. There's a piece on the maintenance enforcement program and the forms that can be filled out and sent to maintenance enforcement program as well. So it's really a one-stop shop, as Leita was talking about, in terms of we put as much content as I think as we could humanly possible to put up there, anticipating everyone's needs for mediation issues and working through parenting issues to child support, maintenance enforcement. It's all there on that centralized hub, and the forms are there with the instructions in terms of how to send them in.
Okay. Which government does child support fall under?
So which
government? I guess which jurisdiction, provincial or federal, is I guess what the question's asking.
Well, our service is under provincial service. We're through Manitoba Justice, and we have our own branch. And so we administer both provincial law, and we have an agreement with Canada to do certain types of child support orders under the Divorce Act. So we kind of deal with the legislation both provincially and federally, but we are a provincial service.
And will you issue?
I'm just maybe sorry, Mary, for all those I'm for all those non-lawyers out there. I think this is something that's really often kind of people aren't aware of. But so the Divorce Act is for married couples, and the jurisdiction for family law is split, and so the Divorce Act is what you would follow if you were married, and the Family Maintenance Act, which is the provincial legislation, would be for common law couple, but you can apply under both, right, Ingrid?
Yeah.
You cannot legally get a divorce under provincial law. You can only get a divorce under the Divorce Act. So there's split jurisdiction.
The beauty of a constitutional system of Canada is that the federal government deals with marriage and divorce, and the provincial government with property, et cetera, like local not marital property, that's Divorce Act, but it doesn't really matter. Like in terms of whether you're getting a support order that's ordered because through the provisions of the Divorce Act, like if the judge says, I'm granting child support of $300 a month pursuant to section blah, blah, blah of the Divorce Act, or if the judge says, I'm granting child support of $300 per month pursuant to section blah, blah, blah of the Family Maintenance Act, or hopefully soon the Family Law Act, it doesn't matter. Like the tables are the same. The child support guideline regulation, which is the law that everybody looks at to determine child support, even though we have our regulation in Manitoba, that's a regulation under our provincial law, and the Divorce Act has their regulation under, the Divorce Act under their law, they're the same. Like we basically, Manitoba said, yeah, your regulation's good, we're just gonna take yours. And most of the province did that. They just said, ditto, is basically what they did. So if you get a child support order, it really doesn't matter. It's gonna be enforced through maintenance enforcement in Manitoba, unless the other person lives in another province, and then it gets a little bit more, there's more questions to be asked, and it can be recalculated by Michael's group. And so really, whether it's under the Divorce Act or the Family Maintenance Act, doesn't matter. So it doesn't, so it's you're gonna get it enforced through Manitoba. You can get one established in Manitoba. It's not a question that you really need to be overly concerned about, to be honest.
I just thought it might be helpful for people to understand why we're talking about these different levels of government and different laws. And and we work really closely with our colleagues across the country too. I was just speaking to a family this morning who was having real difficult time enforcing, a mom, really difficult time enforcing child support. Dad is hiding assets, moved to Saskatchewan. Well, we work closely with our counterparts in Saskatchewan. So there's real partnership across. Ingrid talked about interjurisdictional cases. We work really closely with our colleagues across the country. So I just can't stress enough. One-stop shop, come to us and we'll kind of figure out who are the best specialists to help with a specific situation.
Okay, a few more questions. Will you issue a calculated support order if requested by parties when lawyers are involved in addressing other issues?
The short answer is yes. Yes, as long as that's not one of the issues that they're on the cusp of resolving. We always need to check to make sure that we're not inadvertently interfering with parties who are very close to a resolution. That's the only one that is a concern of the service. We want to make sure that everyone's clear that we're going to go ahead and make a child support calculation decision. If they want to address the other issues, property issues, spousal support issues, we can do that independently of whatever they're deciding to do with the other issues. We'll make that decision, but we like to double check to make sure that the parties are stuck or having difficulty with the child support. We'll get that piece done, but we do like to check to make sure that we're not interfering with something the parties are close to resolving between themselves or with the assistance of legal counsel.
Okay. And if you're relocating and you have a court-ordered child custody agreement, do you still need to complete the relocation form? Is it the same as the one under the Divorce Act?
So it depends on whether your court order is under the Divorce Act or under provincial legislation. If your court order is under the Divorce Act amendments are already into effect, and someone who wants to relocate has to follow the relocation provisions under the Divorce Act. And that involves giving notice to the other party, providing contact information. There are exceptions in cases of domestic violence. If it's a situation where somebody is relocating because they need to escape an abusive partner, then you can go to court and not serve, like it's highly unusual, but you can go to court and you cannot tell the other party you're going to court and ask the judge to make an order that you can move without notifying the other party, and you don't have to provide information. That's really unusual. That's in a case of the kind of domestic violence where someone's escaping. Generally speaking, if it's Divorce Act, you need to follow the provisions. If it's under the Family Maintenance Act, it's not yet those same provisions. Hopefully it will be soon, but generally speaking, yes, like people are going to have to give notice of that they're going to move, when they're going to move, where they're moving to, and then it's kind of a really big long thing that I can't really get into now, but if I would encourage you, it's actually like just go and look at the Divorce Act. Like if your matter is under the Divorce Act, well, no, first I'll say go to the Family Resolution Service, and a family guide can help you figure that out. Sorry?
Yeah, there's information, there's some basic information on it on FLMB on the website.
Yeah.
And then yes, please contact Get Guidance and we can hook you up with a family guide who can explain court process and family law.
Yeah, because it's not super straightforward, and it's a big deal. It's a really big deal. So before people make moves and are starting the planning of accepting jobs and selling houses, etc., it's really, really wise to look into that first.
Okay, there are cases where self-employed individuals have income tied up in their company and claim a very small income. Any changes that have given more leverage to access hidden funds?
The short answer is no. It's really the same process as it once was. One thing that people have to understand is that if someone runs a corporation, that the operating mind behind a corporation, they have control of a corporation. Although we will do those on a recalculation, typically we won't do them on a calculation process, just on recalculation. It's extremely difficult without having the appropriate advice from accountants and others who are expert on certain matters to be able to determine by simply looking at a corporate return exactly what is going on in terms of the corporation. I mean, people look at things like retained earnings, where the retained earnings is going up year after year, but little is being paid out of the corporation as dividends. But there's all kinds of simple little tests that lawyers do to sort of see what's going on with the corporation. But there are certain cases that are sufficiently complicated that our service, for example, wouldn't be able to touch them. We can identify for the court and red flag things that we think are important that potentially the court may want to look at. But there's a number of things that the court can do that we can't do, including imputing some corporate income and some other things that the service really wasn't designed to do. So we're very good with people who are sole proprietors. We can deal in some situations with very limited professional partnerships. But when you're getting into a closely held family corporation or a corporation where the operating mind of the corporation has access to and decides when to pay out dividends, then it's time to think about potentially going to court because the service is likely not going to be able to assist. We just don't have access to the type of expertise that you would normally get if you were in private practice. To be able to sort through exactly how the corporation's being run. So all we can do is really red flag, hey, we think there's an issue here. But normally that's a type of case that would probably have to go to court, or perhaps that would be an appropriate case for arbitration between two parties with an expert arbitrator familiar with corporate law matters.
And then there's the family farm income. Those are always really hard. I shudder. Oh, no, not farm income.
Yeah.
Yes.
Yeah, that's a really regular question on the maintenance enforcement side. And I didn't talk about this in the presentation, but the maintenance enforcement program on the enforcement side, once an order or Michael's decisions in place, we have some of the broadest powers across the country to enforce those orders, and we have a special investigation unit that does look into them. We regularly tell our MEP clients that if they have information about people hiding assets or disposing of assets, those kinds of things, that it's really helpful for us to get that information from them, from the other party who's not getting the payments that are ordered, and they have deep powers and abilities to look into those things. Now, when people are not following the law, it takes time, it takes a lot of effort, but they have had some success using their investigative tools and powers to ensure people that are following, living up to their obligations.
And there's one more question. I went to the family maintenance downtown, and the receptionist told me I need a court order requesting how much money if I wanted to apply and register for child support. Is that true?
Not following that question at all.
You know,
Maybe.
I think maybe there was nothing like you should think of the maintenance enforcement, and this is a simplification, but it's like the collection agency. So there has to be a debt to collect. So perhaps that person didn't yet have an agreement or a child support order. And so if they go to maintenance enforcement and say, I need child support, they will say, well, we can't help you because there's no existing agreement or order. So the person that you need to talk to, if there is not yet an existing order or agreement, would be the child support service via family resolution. Because really, like I'm oversimplifying it, but they're kind of like the collection agency, and there needs to be a debt first before they can collect.
I like the analogy. That's actually very good. Okay, any other questions? Because I think we're kind of running out of time here. But we can certainly take a couple more questions. Anybody has anything else? Okay, in the meantime, I'll ask people to please fill out the survey. We do take your suggestions into account in future programs. I'd like to thank the panelists, Ingrid, Leita, Michael. Thank you for taking time to give us a great three great presentations. And thank you for agreeing to share your slide decks. And I don't see any more questions, but anyway, wait one more minute and then see if we have anything. No. Okay, well, it's like I said, we're past the time. Thank you all for your wonderful presentations. Thank you everybody for attending. And as I want to remind you one more time, please fill out those surveys. When's the pandemic ending? Oh, so soon, hopefully. Okay, thanks everybody. Have a great afternoon.
Okay, thank you.
Bye.
Bye.